Welcome back to the channel, folks, and buckle up, because today's case spirals from a simple tether violation into an explosive bond showdown. We're in Judge Estie's courtroom, and right out of the gate, the defendant's attorney is fighting to explain why her ankle monitor wasn't charged. But as you'll see, the prosecution has receipts, detailed logs, missed calls, and an escalating pattern that paints a very different picture. By the end of this hearing, the judge's patience will run out in a way that will have you saying, "Did that just happen?" Stick around, because we've got tether tech fails, legal strategy clashes, and one very expensive consequence.
So pull your pants up. Next time wear a belt, you're in court. Understood?
Yes, sir. Good morning, Rob Jacob on behalf of Ms. Brookshire.
Marie Brookshire.
Judge, today's PCC, we're asking this matter for a preliminary exam. And
Discovery is complete.
Yes, Your Honor. I met with her at the jail last night. We went over the police report. I would ask if we could address bond.
I have a tether violation.
Right here, defense counsel tries to get ahead of the violation by framing it as a technical glitch, not a willful act. This is a smart legal move. If they can make it seem like a malfunction, they avoid the appearance of defiance. But remember, in tether cases, the law sees it as the defendant's responsibility to keep it charged, no matter what. If the
Judge, the only thing is, speaking with my client last night at the jail, is the violation is that she couldn't power up the tether. She's still wearing it. And she was released originally on PR bond with the tether. She had problems charging it. And I believe that's the violation itself. What we're asking if the court would please consider just to really restore it back to PR bond. I would ask for without the tether, but if it has to be the tether, if somebody could look at it, she's still wearing it. It doesn't work. So we just need to get that straightened out. For my client, the tether was acting up when she was brought into the jail. So I don't. Okay. I just think the tether people have to either come and adjust it or get a new tether, or hopefully without a tether.
Did she contact the company when the alarm was going off?
Your Honor, I did, but my problem was I couldn't see very well because my contacts, and I accidentally typed in 8100 instead of 8160.
Listen closely. The defendant admits she called the tether company, but entered the wrong phone number due to vision problems. While that might sound like an honest mistake, in the eyes of the court, this could be seen as negligence. Legal tip here: in cases involving court-ordered devices, any lapse.
My dad looked at it, and we both double-checked, and he couldn't see it. He put the wrong one. But I did leave 2 messages for Brian Levitt. He told me to charge it for 20 minutes. We agreed on 20. I did 35. I called him after to see what my percentage was. I left him a message. Then when it was going off, I called him again, left a message. When it was going off, me and my dad both attempted to call. And my phone was dead, so I couldn't get his number. Right.
I don't have any of that.
The prosecutor wastes no time. They bring up a formal violation report and highlight that the defendant ignored clear, documented instructions. In courtroom chess, this is a power move. Instead of debating the malfunction, they focus on that
information regarding any call to community correction or anything along those lines.
So I had the opportunity to read the community corrections violation report that I believe Your Honor has as well. And that's not what's reflected in community corrections violation.
I don't. Hang on. I have the sheriff's office report.
I have a bond violation of community correction.
I do not have that.
Which I don't have. I don't know what it says, Your Honor, but I'm just asking if the court would please consider a lot.
Well, I got to figure out.
Mr. Levitt, and I can provide the court. Do you want me to email this over?
Yes, when you get a chance, that'd be great.
Yes. Mr. Levitt gave her very specific instructions. She was advised to charge it immediately after meeting community corrections, and she was told to, I'm still speaking, she was told to charge it for 2 hours. Mr. Levitt is the...
Pay attention to the precision here, exact times, dates, and charging durations. This isn't just storytelling, it's evidence presentation at its sharpest. By showing the tether was only charged for 35 minutes instead of 2 full hours, the prosecutor undercuts the defense.
The person that had to make contact with her while he was sending, he got an alert that the device had low battery. He attempted to contact her on the number that she provided. him. That was unsuccessful. He started sending alarms and sirens repeatedly to the advice. Finally, the defendant, finally, I should say, is, I'm really bad at math, 6 hours later, the defendant calls from a different phone number. He goes over the instructions with her again and says, I instructed them to charge it for 2 hours. She said she could not charge it for 2 hours. I told her it was her responsibility to keep the device charged and that it was critically low. And that's, excuse me, if it gets critically low, this will be contacted. They acknowledged this when the phone call ended. They then only charged it for 35 minutes. So she was given very clear directions on what to do. That was from June 10th, the first time it being low at 1 a.m. Then June 10th, 7:47 p.m., we received another low battery alert.
And here's the bombshell. Not only is the defendant facing a tether violation, but there's now a new stalking charge on the table. This changes the stakes instantly. Judges tend to view violations in a harsher light when there are fresh criminal charges.
For the defendant, all attempts to reach the defendant were unsuccessful. At 7:48 p.m., Washington County Dispatch was contacted, advised of the violation, and was asked to have an officer respond to take the defendant into custody. Contacted by Deputy Mays, who was on scene with the defendant. They were claiming they had been trying to charge the device and were unable. Deputy Mays was told they needed to be arrested on the violation. The defendant had only charged for a total of 45 minutes in the last 5 days. At 9:05 p.m., the defendant was tracking at the Washington County Jail. So the device is working. In addition to this, my office just charged her with stalking in a separate case.
A $10,000 cash bond request is significant. It's designed to keep the defendant in custody unless they can produce a large sum up front. This isn't about punishment yet. It's about risk management. The court is essentially...
In addition to this, my office requested a $10,000 cash surety bond at the time of charging this case. This case being today's case, we requested the $10,000 cash surety on putting sheets before Your Honor.
Mr. Kirwald?
I'm keeping the same argument, Your Honor. I'm asking.
Okay. Motion for bond reductions denied. Bond rule.
When the judge denies a bond reduction, it's a clear signal. They're not buying the defense's version of events. The judge here is protecting the court's authority. If they bend too easily, it could set a precedent that tether violations are negotiable, and in cases...
Here in this matter is revoked.
Judge, it's clarification. Is the bond, what are you, $2,000, 10%?
What do you have this on?
I don't know why.
I have 2,010% on this case.
And if she's released, it's on tether?
It's on tether. She'll have the same conditions.
Okay.
What? Oh, no.
And here's the moment everything changes. The defendant mouths off to the judge. Big mistake. Courtroom etiquette isn't just about respect. It's about strategy. Annoying the judge can lead to immediate, severe consequences, as you're about to see.
She is not going to sit there and mouth me. Her bond now is $25,000.
Really?
10%.
Boom. The bond jumps from $2,000 to $25,000 in a single sentence. This is judicial discretion in action. The judge is sending a message. Disrespect in the courtroom will cost you.
Yeah, really? You want to keep going? I didn't think so. Have a good day. 25, 10. Your name?
Gregory Williams.
Next.
And just like that, the judge moves on. No drawn-out lecture, no chance for the defendant to plead further. Case adjourned, bond raised, lesson delivered. The
Time long pants.
Yeah.
So, what just happened here? A tether violation hearing spiraled into a major bond hike, thanks to a mix of missed calls, ignored alarms, and a final dose of courtroom attitude. The defense tried to frame it as a technical